If anyone's wondering why the police may not have time to investigate their crimes, such as a stolen vehicle, a stolen phone, or a stolen bike, even though the person has tracked the vehicle to a location, they've tracked the phone to a location, or they've tracked the bike to a location, but the police don't have time to investigate, this might be the answer. Now, those three examples I use because they are all from people I know, and a couple of them I've done videos on before now. They're all very genuine stories, and they've genuinely tracked those stolen items to a specific location, but the police did not have time to investigate. This may be why, and it may be a huge, monumental waste of police time. But just before I get into that, if you would please do me the favor of subscribing to my channel. I am independent and I depend on you, and I'm sitting here till the late hours of every evening doing videos around my work. So the very least you can do is subscribe. So I really appreciate that. We're headed towards 1 million subscribers. I'm really excited because I can help a lot of people. You can hear my voice going because I've been on the phone all day and I'm doing videos at the end of it. So bear with me. So what are we talking about here? Suella Braverman, MP, has written to the Home Office about non-crime hate incidents. Now, the clue should be in the name. If it's a non-crime incident of any kind, the police shouldn't really be involved because it's not a crime. Now, the police are to some degree there to keep the peace and keep order, but if something's happened and it's deemed not to be a crime, that should really be the end of the police involvement. I would have thought wrong. Now, I will come to the case of Miller and the College of Policing in a moment because that's quite a chilling contrast to what's actually happening. And I use the words deliberately. And you might have noticed I've got a little pin badge here. That is the pin badge of Free Speech Union. This is my membership. I'm a gold member with Free Speech Union. This is not sponsored. Go and join them if you value your free speech. It's a few pounds very well spent. Now, looking at Suella Braverman's letter to the Home Office, this will blow you away. She says, I'm deeply concerned by the large number of non-crime hate incidents being recorded across the United Kingdom. The Free Speech Union received a Freedom of Information responses from 30 of 43, so 13 have yet to respond. Police constabularies detailing 11,642 non-crime hate incidents between 2022 and 2023, and 11,690, so it's gone up between 23 and 24. She says, therefore, the number of non-crime hate incidents recorded by the police actually increased by 0.4%, despite the June 23 raising of the NCHI statutory guidance threshold. So the threshold for recording these things was raised, and yet they've recorded more of these offences. More about that with regard to the Miller case in a moment. This clarified that personal data should only be included in a non-crime hate incident record if the event presents a real risk of either significant harm or future criminal offence being committed to individuals or groups with a particular characteristic. The national total of NCHIs across the country will be much higher, as Freedom of Information requests must be made to each police constabulary, which may provide data to those requesting information. Please, can you explain why 13 of them didn't respond? These numbers are vital as the Home Office does not provide centralised statistics. Obvious question, why not? I think they should. If these are important enough to record, they should be important enough to have statistics readily available, I would have thought. Many statistics just don't seem to be available these days. Suella Braverman writes, I request the Home Office immediately publish the following centralised statistics as a total for each constabulary from 2014. Total recorded, time spent on the recording, total raised by the public but not included on the record, so that will be a more total number reflecting the entirety of the involvement on these things. Time spent investigating these, which did not meet the threshold. And finally, time spent investigating raised hate crimes that do not meet the hate crime threshold, but then become raised non-crime hate incidents. So the amount of police time, we are talking many, many thousands of police hours here. I request the publishing of these statistics to provide a more complex, complete picture of the efficacy of the statutory guidance. It'd be helpful if the data was shown in a per-month fashion to examine monthly increase in each constabulary. Lastly, please can you indicate the current statistics for May 24 to November 24? Obviously, with the instilling of this new government and what's happened and whether they've gone up or down, left, right or sideways. That is the letter. I look forward to any response if we get one. But as I promised, let's go over to the Miller case. Just 2 paragraphs I'm going to leave you with here, which suggest that this is all not just a monumental waste of time, potentially, but a significant detriment to free speech. Paragraph 70, and you can find this case online. It's a public document. The judge said here, that the highlighted section, the judge went on to say that the police's submissions impermissibly minimized what occurred and did not properly reflect the value of free speech in a democracy. There was not a shred of evidence that Mr. Miller, subject to this case, was at risk of committing a criminal offence. It was nothing to the point that Mr. Miller continued to tweet afterwards, warning him that in unspecified circumstances, he might find himself being prosecuted for exercising his right to freedom of expression on Twitter, had the capacity to impede and deter him from expressing himself on transgender issues. He was tweeting about transgender issues. It had a chilling effect on his right to the freedom of expression. And the court said, in my view, the principles of law that protect freedom of expression and which underpinned much of what the judge said in support of his conclusion that the police had infringed his rights were matters that should have led to the same conclusion against the college. This, as the judge put it here, is a chilling effect on the freedom of expression. And countless thousands of hours that are spent recording these things. So this is the latest letter, gone off to the Home Office today, I understand. And this is not the only example. I have had clients, I can't give you too many details so that I can't breach any confidentiality, but I've had situations where, suffice to say, my clients, plural, not all at the same time, separately, separate incidents, I've had clients who have been threatened by the police with prosecution because they raised an issue that, in fact, someone else was responsible for. So my clients, on each of these occasions, separate and distinct events, nothing to do with each other, but separate people had raised complaints to the police of someone doing something, is all I can really say. And the police then threatened them with prosecution to say that they were the one behaving badly, when that's not true. Because I've seen all the facts, I've seen everything that happened, the chronology, everything else. I know that that was not true, and yet they've been threatened with prosecution because they've raised the complaint, whereas the person really responsible ostensibly had no such threat from the police. And so effectively, what this court case is saying, and effectively what this whole situation with these non-crime hate incidents is saying, is that this has been recorded against this person. It hasn't met the threshold for an offence, for charging, for anything else. It's not a crime, much less a hate crime. It's a non-crime hate incident. Well, hating something is not by itself against the law. Now, you can incite hatred and that can become an offence, but we're talking about the situations here that have not reached the threshold to be an offence. So it hasn't reached these cases here to be recorded as a non-crime hate incident. They must not reach the threshold for an offence. So they are not something where they are inciting hatred and things like that. They've not reached that threshold. This is somebody hates something and they've said so, or they've said something that someone has perceived to be hateful. That is not an offence. It is exercising the right to the freedom of expression. I've said before, I don't condone saying things that are nasty and negative and so on, but if someone says something to you, if somebody calls me bold in the comments section and they mean it as an insult, I mean, I don't care, but if they mean it as an insult and I retaliate and I say something back, which I don't, but, well, not usually anyway, but I don't usually respond at all, in fact, but I look for nice comments and I like to reply to nice comments. But if I were to respond with some kind of nasty message, not that I'd condone that, but if I did, that's not a crime. That's the freedom of expression. That's saying what you think in a free society. If then someone reports that to the police and they put it down as a non-crime hate incident, that could be unlawful recording of data against you. And I suspect we're going to get a situation here where thousands, literally thousands of people may well have a valid claim against the police for recording these things. Misuse of their data, because if it turns out that it was unlawful to record that data, and let's not forget that this Miller case was all about whether or not the guidance was correct and whether it was an infringement on free speech. And let's not forget, as highlighted in this case here, paragraph 58, returning to the case, The exercise by the police of their common law powers to record information is extensively regulated by statute, including by data protection legislation and the Human Rights Act 1998. So everything the police record, everything they do, is still governed by data protection legislation. And so I suspect that there'll be literally thousands of people that may have a case against the police for unlawfully recording their data if it turns out they should not have recorded it because it was a disproportionate means of processing their personal data. So I've covered data protection extensively in other videos, but that's what I loosely predict is going to happen here. We're going to end up with a situation where thousands of people may have a case against the police. But I just wanted to bring that letter to you. I thought that letter was interesting at the end of a long and busy day. But as I said, not sponsored, but I make no apology for plugging and supporting Free Speech Union. Go and join. It's a few pounds. Tell them I said hi, and thanks for watching.